Well, good morning, Jagendra Rana here. Our data, our rights, our questions. This is the topic of our day. Our data, our rights, our questions. The data protection law gives Indians a legally enforceable framework to assert their right to privacy, especially against non-state actors. But government agencies have too much latitude. Appellate body needs to have real teeth. 10 years ago, there was no right to privacy in India. Today, after Digital Personal Data Protection Act 2023 was partially brought into force with the notification of rules on November 13, 2025, we have a law that provides a legally enforceable framework for Indian users to assert their right to privacy against state and non-state actors. But the law is not perfect. There is still a long way to go for large data fiduciaries to respect all the rights of Indians and allow them to meaningfully exercise these rights. There's probably an even longer way to go towards making data privacy a fundamental part of the government process. However, because of work of so many individuals and organizations, Supreme Court orders, and finally government, we have this law today. See here how it began. 2016, before EU's GDPR law of 2018 and India 2017, Supreme Court recognition of privacy as a fundamental right in the Pottaswamy case. Data privacy was not a thing. But it became a concern when WhatsApp, which had originally been privacy focused, introduced a policy allowing personal user data sharing with Facebook entities, betraying its own promises. So this involuntary sharing of data with Facebook that had acquired WhatsApp in 2014 felt wrong. So we went to court, first Delhi High Court and then Supreme Court. Government told Supreme Court in 2017 that a data protection law would be in place within the year. However, it has taken 8 long years to get here. Then gains from DPDPA. Essentially, DPDPA crystallizes and recognizes the fundamental rights to privacy of users, that is data principles, against the companies, data fiduciaries or data processors from the perspective of data protection. Now first it applies against the state. This means you can assert your right against private organizations as well as government. So under DPDPA, consent must be free, specific, informed, unconditional, unambiguous, with a clear affirmative action. This means default opt-in options are not consent. Consent must be withdrawable with comparable ease. So dark patterns making withdrawals of consent hard will be illegal. Fiduciaries must limit their processing of the data specifically to purposes for which the consent was sought. So users' rights have also been clearly defined in DPDPA, including obtaining of information about processing of their personal data plus corrections, the completion, updation and the deletion, erasure of personal data. Yes, you can legally compel companies to delete your data unless they have a good reason not to. So DPDPA clearly gives a high degree of protection to personal data of children. It also constitutes the Data Protection Board as the primary regulatory authority functioning as an independent body and as a digital office. So the Act also has a provision for exemptions for startups for certain data processing activities, balancing ease of doing business against the right to privacy of users. Now, some of the DPDPA's aspects are quite glaring, while others will likely improve over time with judicial intervention. For example, there are broad exceptions for processing of personal data by the state, which are not clearly defined. This could result in government overreach. Furthermore, the Act does not apply to personal data made public by the users. This means any personal data personal data you yourself make public would not be protected. So the Act should ideally apply to all personal data without this exception, as sometimes intermediaries are involved. It will also be difficult to know how independent the board is, given that the appointment will be made by government. The RTI Act had also been amended under DPDPA, where Section 44, subsection 3 of DPDPA now exempts disclosure of personal information under RTI. So there was earlier a public interest exception for disclosure of personal information under RTI. DPDPA's maximum fine of rupees 250 crore for the breaches by fiduciaries might be too small for some large companies. On the other hand, a fine of up to rupees 10,000 on users for frivolous complaints, etc., could disincentivize legitimate complaints. Also, board orders can only be appealed before Telecom Dispute Settlement and Appellate Tribunal, so whose chairperson and 2 members are appointed by Center High Courts would have been better appellate bodies. Better than nothing. Is DPDPA perfect? No. But thanks to its right, like the right to deletion, erasure of personal data, are legally recognized, and companies are legally bound to respect them. Over time, we hope that the board, the appellate tribunal, and courts will enforce the law, draw clearer lines on its subject parts, and protect citizens' interests. The journey to see this law become reality has been long. Today we have a law that codifies our rights on our data, and in our opinion, that is a good thing. Thank you. Thank you very much.